Hey everybody, today we're going to be answering the question, is it illegal? Is it against the law to file a patent if you know someone else has already filed something on it? Hi, I'm JD Houvener, patent attorney, owner, and founder here at Bold Patents Law Firm. I've helped thousands of inventors over the 10 years of my career helping bold inventors at Bold Patents. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. Happy to be with you here today to talk about this question, which came in through our Reddit forum. And it's an interesting one about maybe they're wondering whether it's illegal or against the law to knowingly file a patent application, even though you know maybe there's already a patent on it, already a very similar patent application that was recently filed. Well, I think the answer is no. I was quite curious. A few things I want to unpack with that. One, in that sometimes inventors and people that are in the brand new business world, they hear patent pending, right? Investors hear, oh, this is a patent pending product. We filed for patent protection. What we're talking about here is unique, and this is doing something nobody else has done before. And I think if that's the intent of the inventor, to, in a way, sort of deceive an investor or someone else who might be willing to participate with them, help move their product to market, and they're sort of holding this information in that they already know about a competitor, or they know there's something else out there that was done before them, well, it's sort of a disingenuous, right? A non-meritorious patent pending. And it's not real, right? And you'd be fabricating the information, and let's just say it, lying. So when you're deceiving someone else, especially an investor related to your technology, that's not a great way to start the relationship. Unfortunately, they're likely going to hire their own counsel, or they'll see that the application is going to get rejected based on the prior art that you know already exists. I suppose a second aspect of this is some inventors, they don't necessarily understand that patent laws can really sort of become quite narrow and expand within the very nuanced area of law. So let's give an example, about a brand new pocket knife, all right? So if you've come up with a brand new mechanism for a pocket knife, it involves a spring and it simply opens up, all right? And maybe like a switchblade or some sort of activation device that is secure, right? That's gonna be child-proof and be very efficient in the way that it opens. But you look around, do some research before filing, and you find that someone else has done something very similar. And instead of using a spring, they use a simple leaf spring, right? So it's not like a compactable circular spiral spring. They use a leaf spring, and it performs the same exact function. Well, so you're kind of like, oh, this is awful. But what's interesting is you realize that it's similar in some ways, but if you look hard enough and look at enough detail, the fact that your spring uses a different mechanical structure, a different, unique adherence method, right? There's an interesting way that you found to get the spring attached on both sides. Because it's so small, you've solved a problem there. And so you could potentially file a patent application focusing just on your type of spring, okay? So what I'm getting at is that you can really focus in on the details. And even though the actual end product, right, the actual end functionality may be the same, that small little hinge, or can swing big doors. If you've ever read some of those books by Jim Rohn, and it could be a big opportunity. The underlying question there is having a different type of spring, having a higher end maybe mechanism that's more durable. Is that significant enough? Is that differentiation big enough of a difference to make you money in return? And is the market for pocket knives, this type of pocket knife, and yours being superior perhaps than someone with a leaf spring, is it enough to garner enough financial reward to make it worth spending what could be $10, $20 plus $1,000 in acquiring a solid patent? Anyway, hope that was a good answer. I appreciate all the questions we get. If you're still curious about how to get started, please download our Bold Inventors Kit down below. It's a link to do that. You'll learn about my book. You'll have information about patent searching and application drafting as well. It's been a pleasure talking with you here today. Hope you all have a wonderful day. Go big, go bold.